Before you book that flight, before you pack that bag, before you tell your family you're coming home for the holidays, you need to watch this video to the end. Because right now, in 2025, ICE enforcement at U.S. airports has reached a level that we have not seen in over a decade. And there are 4 specific categories of immigrants: legal immigrants, people with pending applications, people with valid documents, who are being stopped, detained, and in some cases removed at the border. Not because they did something wrong, but because they didn't know what they were walking into. This is not a rumor. This is not political commentary. What I'm about to walk you through is grounded in documented enforcement patterns, current DHS policy directives, and real case precedents that are playing out right now across major U.S. international airports including JFK, LAX, O'Hare, and Miami International. If you or someone you love is planning to travel outside the United States, even for a short trip, do not move until you hear what I'm about to tell you. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't do fear, I don't do speculation, I do policy, law, and practical guidance. Because the immigration community deserves real information, not noise. Before we go further, I want to be transparent with you. I am not your attorney, and nothing in this video is legal advice. This content is strictly for educational and informational purposes. Every immigration case is different, and you should always consult with a licensed immigration attorney about your specific situation. Now, let's get into it. Let's start with what is actually happening at U.S. airports right now, because the landscape has fundamentally shifted. Under current DHS enforcement priorities, U.S. Customs and Border Protection, CBP, and Immigration and Customs Enforcement, ICE, have significantly expanded what's called secondary inspection authority. That means more travelers are being pulled aside, questioned, and subjected to detailed document review than at any point in recent years. Now, here's what most people don't understand. When you re-enter the United States, even if you're a lawful permanent resident, a green card holder, you are technically applying for admission at that port of entry. That is the law. Section 101 of the Immigration and Nationality Act defines a returning LPR as an arriving alien in certain circumstances. And in those circumstances, CBP has broad authority to examine your admissibility. The vast majority of travelers pass through without issue. But there are 4 specific profiles right now where that passage is not guaranteed, and I'm going to walk you through each one. The first category is immigrants who have a pending I-485. That's an application to adjust status to permanent resident, and who traveled outside the United States without obtaining advance parole first. This is a mistake that continues to destroy cases. If you filed an I-485 and you leave the country without an approved Form I-131, that advance parole document, USCIS considers your adjustment application abandoned automatically. There are very narrow exceptions, primarily for H-1B and L-1 visa holders who maintain valid status and can re-enter on their visa. But if you're adjusting based on family sponsorship, a VAWA petition, an employment-based petition where your underlying visa has expired, or an asylum-based application, leaving without advance parole is potentially catastrophic. But here's where this becomes critical. Even people who do have advance parole are now being subjected to heightened scrutiny upon return. CBP has the authority to examine whether the underlying basis for your adjustment remains valid. If there are any questions about your original petition, your relationship, your employer, or your continuous presence, that secondary inspection can turn into something far more serious. I want to be very clear. Advance parole is not a guarantee of re-entry. The Supreme Court addressed this in Succar versus Ashcroft. Advance parole is permission to travel, not a visa. And CBP retains independent authority to make admissibility determinations. If you're in this category, pending I-485 even with advance parole, you need to speak with your immigration attorney before you make any travel plans. Period. The second category is conditional permanent residents, people who received a 2-year green card, typically based on a marriage that was less than 2 years old at the time of approval. These individuals hold a conditional green card, and they are required to file Form I-751, the petition to remove conditions, within the 90-day window before that card expires. Now, there are hundreds of thousands of people in this backlog right now. USCIS processing times for I-751 are running extraordinarily long. Many people have filed, received their receipt notice as proof of continued status, and are essentially in legal limbo. Here's the problem. When you travel internationally and return with an expired conditional green card, even if you have your I-751 receipt notice, you are entering a gray zone at the port of entry. CBP is not required to simply accept that receipt notice and wave you through. Officers have discretion, and in the current enforcement climate, discretionary scrutiny has increased significantly. There's one detail most people are missing here. If your I-751 was filed, but you are also going through divorce proceedings, or if your marriage-based petition involved any fraud allegations, even unsubstantiated ones, traveling right now creates an elevated risk that a CBP officer refers your case for additional review. That review could trigger an interaction with an immigration judge before you see your family again. I'm not saying this to alarm you. I'm saying this because it has happened, and it is happening. Let me give you a realistic example of how this can unfold. Imagine someone we'll call Maria. Maria is a Colombian national who married a U.S. citizen 3 years ago. She received her conditional green card 2 years ago. Her I-751 has been pending for 8 months. She has the receipt notice. She decides to fly to Colombia for 2 weeks to visit her aging mother, something she hasn't done in 4 years. She boards her return flight with her expired green card and her receipt notice. At JFK, she's pulled into secondary inspection. The officer notices that her I-751 has been pending an unusually long time and asks a series of detailed questions about her marriage, where she and her husband met, their daily routines, shared finances, their address history. Maria answers truthfully, but she's nervous. She hasn't slept in 20 hours. Some of her answers are inconsistent with the address listed in her file because they moved 6 months ago, and she forgot to update USCIS. She's held for 4 hours. Eventually, she's released. But USCIS is now notified that there were inconsistencies during CBP inspection. Her I-751 case is escalated for an interview she wasn't previously scheduled for. Maria didn't do anything wrong. She was just uninformed about what re-entry actually looks like right now. That's what this video is about. The third category, and this one is extremely serious, includes individuals who have any prior immigration violation in their history. This includes prior overstays, prior orders of removal, even if those orders were administratively closed or if the person subsequently obtained a different status, prior voluntary departures, and prior deportations. In the current enforcement environment, DHS has significantly expanded the category of individuals considered enforcement priorities, and the policy of prosecutorial discretion that previously allowed many individuals to re-enter or remain has been substantially curtailed. Here is what the law says. Under INA Section 212, a person who was previously removed is inadmissible for a period of 5 to 20 years, depending on the circumstances. A person who was previously removed after being convicted of an aggravated felony faces permanent inadmissibility. Now, many people in this situation received waivers, Form I-22 waivers, or were admitted under specific exceptions. But when they re-enter, CBP has access to a comprehensive enforcement database. If there is any discrepancy between what the database shows and what the traveler presents, that individual is going into secondary inspection and potentially into expedited removal proceedings. Expedited removal is exactly what it sounds like. Under current law and current DHS policy, CBP officers at ports of entry can issue a removal order without an immigration court hearing for individuals who are inadmissible and who have not demonstrated clear entitlement to admission. If you have any prior immigration violation in your record, even something that happened years ago, please, before you travel anywhere, sit down with a qualified immigration attorney and have them pull your full record and assess your admissibility risk. This is not optional. This is essential. The fourth category is one that surprises people the most: lawful non-immigrant visa holders, particularly those on H-1B, F-1, and certain other visa categories, who may have experienced a change in their circumstances that could affect their status. Right now, there are specific situations that are creating risk for people in this category. H-1B workers who were laid off, and we know that tech sector layoffs have been substantial over the past 2 years, have a 60-day grace period to maintain status. But if that grace period has lapsed, if the worker found new sponsorship but the new I-129 petition is still pending, or if there are any gaps in authorized employment, traveling and re-entering creates a situation where CBP can question whether the individual is maintaining valid status. An H-1B visa stamp in your passport does not automatically entitle you to re-entry if your underlying status has been compromised. For F-1 students, particularly those who are in optional practical training, the stakes are similarly high. If your OPT employment authorization document has any gaps, if your SEVIS record was terminated for any reason, even a technical one that was subsequently corrected, traveling internationally is a serious risk right now. CBP has direct access to SEVIS. They can see your record in real time, and if your record shows anything concerning, you may not be admitted. This is what many visa holders are fundamentally misunderstanding. Your visa is not your status. Your visa is a travel document that allows you to apply for admission. Your status is what determines whether you can actually be admitted and remain in the United States. These are two different legal concepts, and right now the gap between them is creating real consequences at airports across the country. So what do you actually do with this information? Let me give you a concrete, practical action plan. Step 1. Before you make any travel decision, pull together your complete immigration file. Every document, your original visa approvals, your I-94 records, which you can pull from the CBP I-94 website, your current status documents, any pending application receipts, any correspondence with USCIS. Know exactly where you stand legally before you step foot in an airport. Step 2. Verify your travel eligibility with a licensed immigration attorney, not a notario, not an online forum, an attorney licensed in immigration law who can review your specific record and give you a written assessment of your re-entry risk. Given what's happening right now, this consultation could be the most important thing you do this year. Step 3. If you do travel, carry a complete documentation package. This means original documents, not photocopies of your visa, your I-94, any pending application receipts, your advance parole if applicable, proof of ties to the U.S., such as employment records, lease agreements, bank statements, and any attorney letters addressing your status. CBP officers are more likely to resolve ambiguous situations favorably when a traveler is organized and prepared. Step 4. Monitor the USCIS policy manual and DHS enforcement priority updates regularly. These change. Policy shifts that affect your travel risk may happen with little public notice. The USCIS website, the Federal Register, and credible immigration news sources should be on your regular reading list. Step 5. If you are stopped at the airport, you have rights. You have the right to remain silent beyond basic identification information. You have the right to contact an attorney, though CBP may not be required to facilitate that contact immediately at the initial inspection stage. Do not sign any documents you do not understand. Do not make any statements about your immigration history beyond what is documented. And if you are a lawful permanent resident, do not waive your right to an immigration hearing. Now let me give you the broader policy context because this doesn't exist in a vacuum. The current enforcement climate is shaped by a combination of factors. Executive enforcement priorities set by the current administration have shifted substantially toward expanded interior and port of entry enforcement. Congressional action on comprehensive immigration reform remains stalled, which means the regulatory framework hasn't changed through legislation, but executive agencies have wide latitude in how they implement existing law. There are ongoing court challenges to specific enforcement policies. Some federal district courts have issued injunctions limiting certain enforcement actions, but those injunctions are narrow, they are jurisdiction-specific, and they are being appealed. The broader enforcement posture is not currently subject to any sweeping judicial limitation. What we're seeing at airports right now is fully within the existing statutory authority of DHS and CBP under the INA. However, this protection may not be permanent. Depending on court outcomes, congressional action, and administrative shifts, the enforcement environment could change. Staying informed is not something you do once. It's something you do continuously. Before I close, I want to take a moment to say something directly to the immigration community watching this. I understand what's at stake for you. This isn't abstract policy. This is your family. This is your job. This is the life you've spent years building. The uncertainty is real, and the fear is understandable, but fear without information is paralyzing. What I want you to leave this video with is not anxiety. I want you to leave with clarity. Clarity about where you stand, clarity about what steps to take, and clarity about the fact that you can navigate this if you have the right information and the right people in your corner. Your immigration status touches every dimension of your life. Your ability to stay with your family, your employment, your financial security, your path to permanent residency, and eventually citizenship. That's why staying informed is not optional. It is one of the most important things you can do right now. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop your visa category in the comments below. I read every single one, and it helps me prioritize the topics that matter most to this community. If you know someone who is planning to travel soon, share this video with them today. It could make a real difference. And if this content was valuable to you, hit that like button. It helps more people in the immigration community find this channel and access factual information when they need it most. I'll see you in the next one.